The Supreme Court of India handed down a crucial verdict, upholding the 10% reservation for the economically weaker sections or the poor of our country. India and its constitutional history have not known reservation based on economic status, at least in the present structure and form that we are talking about. Reservation, in principle, has always been about the representation of the historically marginalized communities, like the scheduled castes, scheduled tribes, or even the OBC. Hello and welcome to this edition of Let's Talk Law. I am Sani. Today we talk about the crucial verdict of the Supreme Court on the EWS quota and, more importantly, what lies ahead. By upholding the 103rd Amendment to the Indian Constitution, the top court has given a green signal, ushering a new era where individuals will be given preference by the state for educational benefits based not on their caste but on their economic status. The government has also set parameters as to how and who can avail these benefits. So the Parliament brought in an amendment and the Supreme Court upheld it. So far, so good. But what is the significance of this judgment? What lies ahead? What is the kind of shift of policy does it indicate on part of the Government of India? And in the times to come, is this judgment capable of bringing in dramatic changes to the entire policy around reservations in this country? Also, what are the questions that lie unanswered? First, let me break down this judgment for you. The three key arguments based on which the Supreme Court upheld the 10% reservation for the EWS for the economically weaker section of our country. Number one, the 103rd Amendment is not violative of the basic structure. Now, you must have heard this word many times, the basic structure doctrine. This doctrine that stems from the historic case of Nanda Bharti. Basic structure essentially means few intrinsic parts of the Indian Constitution: equality, justice, liberty, separation of powers, secularism. These tenets of the Constitution, even the Parliament cannot change. They are basic to the Indian Constitution. The Supreme Court sits atop and will strike down any move to alter the basic structure. So it was argued that reservation is about representation of these communities like SC, ST and OBC, which have historically suffered because of their caste-based identity and not based on economic status. That is not allowed under the Constitution. It was not the original idea of the Constitution makers. It was argued before the court. But the majority, the 3 judges out of the 5, said EWS quota is not violative of the basic structure. The Parliament has the power to make such provisions. Let's come to the second aspect. The second aspect is whether by excluding the SC, ST and OBCs from the 10% EWS quota, the government has created an exclusionary policy which is violative of an equality code of our country. What does this mean? It means that they have unreasonably excluded certain benefits from these communities. The majority said that the state has the power to make such classification and also take affirmative action. It does not violate the equality code. Let's come to the third and the most critical aspect, which is still something which needs to be figured out in the days to come. The third argument was a more complicated one, as I said, and it stems from the famous Mandal Commission case, or what you call the Indra Sani judgment of 1992. There's a 50% cap, which means that all reservations put together cannot breach the 50% mark unless there are exceptional circumstances. Now, the majority view has been that 50% cap is not inflexible and it can be stretched. The dissenting 2 judges, Justice Ravindra Bhatt and the former Chief Justice of India, Justice U.U. Lalit, warned against such classification, as they may open up a Pandora's box. So these were the 2 views that existed. Now we've understood the 3 key reasons under which the Supreme Court upheld the EWS quota, the 3 broad arguments. It's not violative of the basic structure, does not violate the equality code, and more importantly, the Indra Sani ceiling limit is flexible, 50% only for SC, ST and OBC. But do not presume that the larger debate is over around reservation. This is a vexed or a troublesome issue. It has not been settled. The last word has not been said. Now, moving forward in the times to come, we are likely to witness some very complicated questions being debated in the top court of the country, and this is the forward-looking aspect of it. The first layer, let's talk about this, and this is the critical part. Indra Sani judgment of 1992. Now, in this case, 9-judge bench by 6:3, 6 judges in majority, 3 in minority, they had upheld the 27% quota for the OBCs. The court had also said that creamy layer can be excluded. That entire concept emerged from this case. And more importantly, the concept of backwardness due to which reservations are granted cannot be given solely on the basis of economic criteria. There's also the angle of caste, historical deprivation, that must be taken into account. That's what this judgment said. Now, the 50% ceiling, if breached by the state or centre in certain circumstances, what are those circumstances? And what is the ceiling in such cases? Earlier, the reservation was only known for SC, ST and OBCs. And with the introduction of a new class based solely on the economic criteria, which excludes the SC, ST, OBCs, what's the ceiling limit? These are the questions that still demand an answer. What stops the government from creating more such classifications and categories? And this argument or this fear also resonated in the dissenting judgment of the two judges. Moving forward, where is the full stop to this argument really lie? We must understand that the change or the amendment brought in by the government is in Part 3 of the Indian Constitution, which deals with the fundamental rights and forms the basis of the Constitution. It is indeed a watershed moment, a historic change, and it's likely to spur more reforms in the future as well. Now, here is an important argument. I also wish to make an argument for the posterity, anticipating more constitutional changes in the times to come. While there is no doubt that the reservation for SC, ST and OBC community is untouched, nothing is being done to take away those benefits. And the government has clarified that position, that there is no intent to do away with the reservation for these communities. Discrimination based on caste was directly linked to one's social identity. And even today, despite stringent laws, caste-based violence and discrimination remains a stark reality. No one can deny the facts that I just stated. But directly opposed to the caste-based reservation in our country, there is now a reservation based on economic status alone, which has been created under Article 15 and 16. A parallel stream of sorts has been created. But 75 years post India's independence, is there a case to be made for rethinking reservations in India? The two judges on the bench, who in fact upheld the EWS quota, reiterated that originally reservation was envisioned only for a very limited time. The politics of reservation has only deepened the fault lines along the caste identities in our country. And we are still far away from totally eradicating the social injustices. But a fresh debate will ensue in the times to come, not only on cases like Indra, Sani or the overall ceiling limit of reservations, but on the overall form and structure of the reservation system in India. A much needed debate that in the times to come we shall witness in the top court of the country.